the following has occurred in the interim. We have been furnished with quite voluminous extra information. Let me call it information for purposes. So the information that needs to be canvassed and dealt with and that relates inter alia to the 10.6 has increased almost tenfold. Last count, and that was before we got a further email last night, the volume was far exceeding 2,000 pages. It's common cause between us and the evidence leaders that we were only served with bundles yesterday afternoon. We could only then take it in. We had no opportunity whatsoever to canvass the content of these bundles. It's common cause between us that it far exceeds the, let's say, what was contained in the Rule 3.3s, and there's quite an array of new information in it. That information, inter alia, relates to issues that was canvassed in the 10.6 that we, I respectfully submit, now have an opportunity or should deal with in a supplementary fashion with our affidavit. There's information contained in there that was never within the purview of my client. That's the first issue. We have also, I've had a discussion with my learned friend, and I'm raising this ahead of my client being sworn in and dealing because it would guide the way forward. We do intend to take issue on quite a number of legal aspects. I've approached my learned friends and we've come to an agreement that it can dispose of where we're going further in this matter. I'm not going to go into the detail of that. I have indicated to them that we are busy with also because of course, what my learned friends have told us, their approach to the matter. We've decided that the best way to deal with it is to file the supplementary affidavit and deal with the legal issues in it. That would give the evidence leaders the opportunity to answer to the legal issues that we raise. We will, of course, if necessary, because it's legal, supplement it if necessary, draft heads of argument and then deal with those issues or argue those issues, and for you then to make a ruling on it. Our approach was that we file the supplementary affidavit and that it be dealt with together with the affidavit that's currently before you, because some of the rights that is laying claim to in this affidavit has no legal basis. In other words, it's not explained to you as the commissioners why he is claiming this right. So the legal basis for it is not in there. There was good reason, and I don't think it's in the interest of anybody that I, at this point, deal with why it was not, the basis of it was not laid at that point. My learned friends have indicated that if he reads out the affidavit, they're not going to ask him any questions on it. My concern is that if, for instance, you as the commissioners wish to ask points in clarification and it relates to legal points, you know, what do we do there? We say that our supplementary affidavit will take care of any concerns that you might have or any questions that you might have based on, let's say, the points in limine. I want to call it that because I think it's a good way of explaining that. Let's say the client says, I'm not dealing with any questions pertaining to it, to person X that you've listed in your 10.6. I say, as an example, I'm a suspect in a matter that relates to person X that's named there. We think, as I've indicated to you, that the way to deal with it is then to deal with that issue in the supplementary affidavit with a proper legal basis and then explaining factually why we say we are a suspect so that everybody is on the same page. And as where I started off is that you then make your ruling and say, you're not a suspect, you have to answer questions pertaining to witness X. Or you uphold our point and say, well, in law I agree, you are a suspect and on this issue. In other words, the evidence leaders cannot traverse anything pertaining to witness X. That is, in short, where we are. So my suggestion, or my respectful submission, and not in the way you interpret respectful submission, Chairperson, is that we be given, because we've already got dates in mind and we agreed on timelines, that you afford us the opportunity to file the supplementary affidavit so that you can read it in conjunction with the affidavit that's before you for a full and complete understanding of the legal and factual basis on which the rights that the client claims in there is, or how he claims it on. That would also give us an opportunity, as I say, and that's the second leg of it, to now deal with totally new matter pertaining to the, let's call it the Annexure A, that very long list, where the state, sorry, not the state, the Commission, the evidence leaders has now come up and included documentation or references to those people in the bundle. It also gives the client the opportunity to deal with those and respond to that. Thank you very much.
Thank you, Ms. Van Heever. At the beginning, I thought I understood you to say that Mr. Matlala, I assume after advice from you, has agreed that his statement should be read into the record. No. And I understood that to mean that's going to happen now. But as you went on and mentioned the supplementary affidavit, I got confused, and especially once you said that the two statements should then be read in conjunction with each other. So I got lost, and I do not know whether you are saying the statement that we have now should not be read, and that the two, that is this statement and the supplementary statement, should be read together at a later stage.
So maybe I'm
confused.
Maybe I should clarify. That is our first preference, that we deal with it in the way, and that is what I pitched or I proposed to my learned friends, that you wait, let's file our supplementary affidavit. We intend to file it within days, because we need the opportunity to canvass all the material. There's literally, you can see, I think there's 4 boxes here on top of each other with material.
So your alternative, which is my understanding of what you said at the beginning, so the alternative
is he reads it in without any questions of clarification, and that is parked until such time as the supplementary affidavit is filed, because that would take care of any questions of clarifications that you as the commissioners may have. My learned friends, I've got no issue with. They've already said we're not going to ask questions. My concern is if you, for instance, wish to raise and say, you say that you're a suspect in this matter, explain it to us. We do not believe that it would be fair to the client that it be dealt with in that fashion. We say, give us the opportunity to file the supplementary affidavit, then you can read it as one, because we will cross-reference the answers, and it would shorten the proceedings in any event. It would most probably answer 99% of any questions that you might have initially on clarification issues, because it will be dealt with factually and legally.
I have not conferred with my co-commissioners, but I do not see any problems with clarity-seeking questions that are purely on factual issues. So I hope your submission does not go to the extent of saying no such questions of clarity. That is not even on pure simple factual issues. I hope you are not going that far.
Chairperson, of course, you always have, I know your act, I know your rules, I know your regulations. You are entitled to ask questions of clarification. Yes, right. But those questions of clarification, we respectfully submit, must be dealt with in conjunction with the rights that we claim. And that's why I said, I think it will make it easier for everybody, and I apologize for repeating this point. Yeah. If we file the supplementary, then we're all on the same page, an argument goes to the heart of what is contained there. So if you were, for instance, to ask a question and clarification, and we say that, you cannot do that because of the legal issues, then that brings to an end to it. But if I could just go one step further, that's why I've also indicated to you, we believe that it would be in the interest of everybody concerned and the business I respectfully submit of the Commission if we deal with the what I call the points in limine first, because that will be the positive of anything that goes forward. Because if you uphold our submissions that we make or the points we raised, then it's clear for everybody you cannot go there. But if you don't, yes, then we are where we are.
Thank you. I would rather we start with the reading of the statement, and we will ask clarity-seeking questions, and if you happen to have issues with those, you can raise the issue at the relevant time. There are two issues I want to raise with Ms. Sello. Did you want to say something further?
No, Chairperson, I just want to say, so if I understand your ruling,
yes.
Read in the affidavit?
Yes, yes.
At this point?
At this point, yes, yes. Oh, two issues. We have received quite a number of these complaints by witnesses that they have been furnished with voluminous documents at the last minute. You might just want to address us on that, please. And then, secondly, an experience we have had is, I forget who the witness was, but the name is not important anyway, where I think the bundles went up to, or rather were in excess of 4,000 pages. But for practical purposes, what the chief evidence leader, Mr. Shaskalson, did was to say to the witnesses' legal representatives, we are only going to use X number of pages in these bundles. And that number of pages was only in the hundreds. It did not even reach 1,000 pages. So we have been told that the bundles here in Mr. Matlala's matter are in excess of 2,000 pages. If you are in a position practically to say to Ms. van den Heever, of the 2,000 plus pages, we are only going to use X number of pages, please do that. Thank you.
Thank you, Chair. And before I do so, if I may, with your leave, address a fundamental error that I think Ms. van den Heever made, which is, to her understanding, the evidence leaders had undertaken not to ask questions of clarification. It was to the extent that she so understood that was a complete misunderstanding on our part, because that effectively would be treating Mr. Matlala differently from all other witnesses. The process that we had suggested, when it's his own time to narrate his story, is that he's subjected to questions of clarification, both from the commissioners, and we have no control over that, and that we too may have questions of clarification, and we leave it at that. So I just wanted for the record to correct that, to the extent that she understood that to be our position, then we either miscommunicated or she misunderstood us. Turning then to the issues that the Chair has posed to me directly. Yes, Chair, the bundles were unfortunately delivered very late. As Ms. van den Heever points out, we've been in engagement for an extended period, including the whole of last week. And it was hoped that in the course of last week, at least the electronic bundle would be available. That too was late. The system somehow was not coping. In large part because, Chair, when you postponed the appearance of Mr. Matlala, it was for the 1st of September. Mr. Matlala then presented himself in his criminal trial, and the judge set out a program for that particular trial, which ensured that we are able to have access to Mr. Matlala for purposes of this commission without necessarily prejudicing him in the criminal trial. And then the only option available to us was then to bring it forward by 2 weeks. In that period, our systems were preparing for other witnesses until the 1st. And it was not the most ideal, but where we landed was that even the electronic bundle was issued late. Then, as luck would have it, Murphy's Law crept in, that itself, it had problems, because when you click on the document that the index suggests is the document being presented, then the document comes out blank. So there have just been just a comedy of errors regarding the bundles. So Ms. van der Heever is quite correct that they were given late. Even we, as the evidence leaders, received ours very late, including the last batch by yesterday, last night. So we do appreciate the position that it places her and her client in, and that they do require time to apply their minds to the bundle. And we have no challenge in them being afforded the opportunity to do so. We believe that they are so entitled. The bundles are voluminous, and yes, they're in excess, I think, a total of 2,000. There is a slight difference, however. When the Rule 3 notices were served on Mr. Matlala, they were, as is standard, served together with excerpts from the relevant witnesses, where it is, our interpretation was that Mr. Matlala was being implicated. So he got only excerpts, transcripts and statements and documents from the evidence of the testimonies of the witnesses that appeared. The approach adopted in the compilation of the exhibit bundle was slightly different, which is to provide, if it's an excerpt from a statement, to provide the full statement so that appropriate context is taken when Mr. Matlala has to consider. So that automatically increased the number. So it's very easy to identify the documents, to say when you were given a Rule 3, you were given excerpts from this particular document. We've now made the full document available to you. And that full document will, of course, traverse issues that are wholly irrelevant to this particular witness, because the excerpts would have done that. But for context purposes, we decided to provide everything. The same goes for the chats, WhatsApp chats that were relied upon. He was previously given chats relied upon in evidence, but now there's been a fuller disclosure of the chats for a certain period, and that added to the volume of paper. Thirdly, it is possible to direct Ms. van der Heever on the relevant portions for purposes of our engagement with Mr. Matlala that we'll be relying on, so that they don't necessarily have to troll through all 2,000 pages. So we can do that. It's a question of how we've got proposals in that respect. It's a question of where we land in terms of dates, because if we are given other dates that are not successive, we are able to identify for purposes of a particular date what topics will be covered, and therefore what documents will be relevant from the exhibit bundle. And so to the next date and the third, if possible. If there are successive dates, then we might as well just do a complete sweep of the bundle and say these are the documents that are going to be relevant. I will confirm for the record that everything that was given to him in terms of the Rule 3s will be relevant for purposes of preparation. Thank you, Chair.
Thank you.
Chairperson, I appreciate what my learned friend has placed on record. The proposal that we be told, let's say for a particular date, this is what's relevant, might be a bit problematic, because our client is, unlike most witnesses that appeared here, not a man roaming the streets. We need access. We need that access is exceptionally limited.
May I make this request, Ms. van der Heever? Let's start with a statement, and once we are done with it, may those logistical issues be discussed between you and Ms. Sello.
I'm quite happy that we do that. Thank you, Chair.
Thank you, thank you. Mr. Matlala, will you be swearing or affirming?
I'll be swearing.
Can you please state your full names for the record?
Say that again.
Please state your full names for the record.
Musi Matlala.
Do you swear that the evidence you are going to give is the truth, the whole truth, nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you.
Thank you, Chair. And I haven't had the opportunity. Good morning, Mr. Matlala.
Good morning, Commissioner.
Mr. Matlala, you should have by you a fairly small white file. And
I think the witness's file has been taken away. We'll just go on, look at it electronically. It's just going to be a bit of an issue pertaining to the paginated numbers, but I've handed mine over just for purposes of getting away, moving along.
Taken by who so that we can track it down?
I think the attorneys took the boxes with, but it's not an issue. Let's just move on. You can use mine in the interim.
That's fine.
Thank you.
I hope that the file you've been given accords with our paginated version. But let's start with the cover. It should bear your name on the spine and read Regulation 10.6 notice, statement and annexure. Is that what you have?
Yeah, it is.
Thank you. Now, you do confirm that you have filed a statement in response to a request by the Commission to address certain specified questions that were posed to you. Is that correct?
Yes, I do.
I would like you to, on that file, then turn to page 8 and have regard to the contents of the document appearing from page 8. It runs until page 17. And it has in the trim lines at page 8 the word affidavit, and it purports to be your affidavit. And if you go to page 17, this is a document, an affidavit sworn to by yourself on the 2nd day of August 2026 and bears a signature above the word deponent. Do you confirm that's your signature and that the details I have read are correct?